Today, we are going to be talking about a lawsuit that's been recently filed in California challenging a California law that Governor Newsom signed into existence back about 7 months ago. This law is called AB 1594, and it is a just unbelievably egregious violation of the Second Amendment. Now, if you're not in California, don't disregard this video. Things that happen in California are kind of like pathogens. They make their way across the country. And many of you are probably well aware of the fact that Gavin Newsom, our governor here, is clearly setting himself up for a presidential run. Whether that happens this year or whether that happens 5 years from now, we'll have to wait and see what actually is going to take place. But he's clearly positioning himself, and he's virtue signaling to a lot of his cohorts that are in the anti-gun community. Many of these people are judges, and a lot of them are in state legislatures throughout the country. So again, we all have to be vigilant, okay? So what does this law actually do? Well, quite a lot, actually. The first thing that it does is create a new class of individuals at a corporate level. All right, these are what are referred to as firearms industry members, okay? And that is a massively vague and ambiguous term. We're not entirely sure what a firearm industry member is. Now, a little backstory for a few minutes. So there were a lot of lawsuits that were levied against gun manufacturers back about 20 years ago. A lot of anti-gunners decided that one of the ways they could put gun manufacturers out of business was just to sue them every time someone misused their products. All right. Now, if I manufacture a hammer, everybody can tell that a hammer is there for the purposes of hammering in nails, right? Well, if somebody takes my hammer and then ends up using it to kill someone else, that is not the intended purpose. That is not why the hammer was originally sold. The individual that committed the crime obviously can be prosecuted and is subject to civil liability, but the manufacturer of the hammer could essentially say, hey, listen, that weapon or that hammer was weaponized and was not used for its proper purpose. It was used in a criminal act. It is sometimes referred to as a third-party intervening event. It reduces completely negates the proximate cause. We won't get into tort law on this, but that is effectively their argument. Well, that all notwithstanding, and while those arguments still existed for gun manufacturers, they were going to be sued by multiple individuals every single time somebody used a firearm to commit a crime. Guys, this video is being sponsored by USCCA. Now, they're doing a giveaway right now. It's all of the information is going to be located in the description below this video, but you're going to want to click on it. You're going to want to participate. It does end soon. What they're giving away is unbelievably cool. I'll give you a hint. It can fit in your holster. So Congress, knowing that this was going to effectively bankrupt gun manufacturers, created a federal law. This is the Protection of Lawful Commerce in Arms Act, or the PLCCA. Now, this essentially gave a certain degree of immunity to gun manufacturers. And I want to be very, very clear on this, because you hear President Biden talking about the fact that gun manufacturers are completely immune from all civil liability. That is what we call a lie. That is absolutely an inaccurate statement. It simply reinforces the already existing common law presumption that when someone misuses a product, and using a product to engage in an illegal act is by definition a misuse of a product, the manufacturer of that product cannot be held liable. All right. If a manufacturer were to develop a Mega Blaster 3000 with a material defect in it, and when the ultimate user fired the gun, it exploded and injured or killed several people all around them, the manufacturer would still be liable under a strict liability theory. All right, they're introducing a product into the marketplace. They have a duty to ensure that that product is safe for its intended purpose, okay? So that never went away. Manufacturers could still be sued. It's just that if somebody were to take this product, like a gun or a hammer or a saw or a baseball bat, and they were to use that in a criminal act, the manufacturer of that product could not be held liable. This makes reasonable sense. Well, after the Bruin case came out, we created the constitutional test, and we won't go through all of the vagaries associated with that. But California had already decided that they were going to try to create this law that essentially negates the federal law and allows people to sue not just gun manufacturers, but all those industry members that were involved in the sale of a firearm. So this would absolutely be the original manufacturer of the firearm, who may or may not exist in California. It most likely is going to be an out-of-state actor. It could be the individuals at the distribution level that then subsequently sold that firearm to a firearms retailer. It would certainly be the firearms retailer. It could be, just about anybody involved in the process. Firearms trainer, you name it, okay? So this was to create this class of individuals that now had this incredibly robust level of protection that they had to develop to protect the vulnerable citizens of California from all of these firearms. Now, it also created a subclass dealing specifically with minors, okay? Weapons could not be advertised, marketed to minors. Now, at first blush, a lot of people looked at that and said, well, kids don't buy guns, so why is this even relevant? Well, that's not an entirely accurate statement. That's not what the law says. It cannot be marketed. You cannot have any sort of educational background associated with it. It cannot be shown in a positive light. Okay, this is incredibly vague and ambiguous. Incidentally, this potentially could implicate Hollywood, because if Hollywood has a production set going on, there is an armorer, and we all are very familiar with that, with Alec Baldwin on the Rust movie set. So there is a firearms industry member in this production, right? And now you've got individuals within the movie, think of any Marvel or DC Comics movie, using weapons in a way that could encourage youth to want to get these weapons. This means that the entire, production is potentially liable for violating this code section. Now, trust me when I tell you the California Department of Justice would never go after a film produced in Hollywood. Produced in Atlanta, Georgia, maybe a different story. But it does, create this natural prohibition. It also would effectively negate the sale of, say, .22 cricket rifles. If I wanted to teach my daughter how to shoot a rifle and I wanted to purchase a .22 cricket for her, couldn't do it, right? That would be a weapon that is specifically designed for children. If I wanted to get a 20 gauge shotgun and get a youth version of that because I wanted to introduce my daughter to hunting, I couldn't do that, okay? So there clearly is a Second Amendment related claim here. But the claim is actually greater than that. There's also a First Amendment claim. There is a what we call a preemption claim. There's a supremacy clause claim. The federal government has already spoken on this. There already is a federal law. A state law cannot supersede a federal law. And yet, California did it anyways. There's a famous quote by a California legislator that said the Constitution simply is not taken into account when generating a law in California. And that is clear in this particular form of legislation. There are First Amendment related issues, and then there's this concept of unconstitutional extraterritorial regulation. So remember, I referenced the idea that a production company in Atlanta may be held liable for what they've produced that are being viewed by California residents. Well, we can take this to somewhat of an extreme, right? You can have gun manufacturers being subject to a lawsuit when a gun that they're manufacturing never makes its way into California, right? I mean, you've got a gun manufacturer in, let's say, Tennessee, manufactures this infamous Mega Blaster 3000. It is given to a production company in Atlanta to be used in a film. The kids are watching this movie in California, and there's a lawsuit levied against not only the production company in, Atlanta, but also the firearms manufacturer in Tennessee, even though none of them have any nexus to California. So it's unconstitutional on that. I mean, there's just a slew of things that make this law completely noxious. Now, again, it would have been reasonable for the state of California to hit the pause button as this thing was going through the legislative process and look to see Bruin and whether or not this might in fact violate any constitutional laws. But they didn't. They just moved straight forward. This lawsuit drafted by Mr. Clement and Miss Murphy, it's exquisitely drafted. For those of you who've read any Roger Benitez decisions before, specifically on Duncan v. Becerra or Duncan v. Bonta, he has quite the turn of phrase. Paul Clement and Aaron Murphy are similarly gifted. So I would encourage you to read the complaint. That again is NSSF v. Bonta. And we can get the links to that complaint in the description below this video. It's good reading, but again, it's cautionary reading because again, if you don't live in California, do not ignore this stuff. It is coming to a theater near you, all right? And how we defeat it in California sets the groundwork for how we defeat similar initiatives that are raised in other jurisdictions across the country. As always, if you'd like to contact me, please do. My email address is steven@artemishq.com. And as always, train constantly, train consistently, train repetitively, and train with purpose. Above all else, stay safe.
Before you go, you just missed one of our best videos that got over 500,000 views. Click right here to watch it now.